Hello, and welcome to Montgomery County Office of Consumer Protection's presentations on credit, debt, and collection. During the pandemic, the best way to reach us is at the email address you find at the bottom of this slide. In addition to programs such as this, the Office of Consumer Protection handles disputes between merchants and their consumers. So if you have paid money towards a good or a service and the transaction isn't meeting expectations, file a complaint with our office and we can help you and the merchant come up with a resolution. And since we are a law enforcement agency and enforce the consumer protection laws, if there's been a violation of the consumer protection laws, we can take appropriate enforcement action as well. We also provide consumer specialists not only through the email address on the first slide, but when the phones are on, when we're not in the midst of a pandemic. We also handle no appointment walk-ins and phone calls if you have any consumer-related questions. Lastly, we handle the licensing and regulation of certain industries in the county. So if you're getting your car repaired, they should hopefully have our registration. If you're buying a new home, they should be licensed by us. If anyone's coming into your home to repair the refrigerator or a consumer electronic, they should have our license as well. And lastly, for the police department, we administer the secondhand personal and property dealer's license. To start at the very beginning of this issue, let's start with what the definition of credit is, because this definition weaves itself throughout everything we're going to talk about today. The definition of credit is the ability to borrow money or to get goods by paying little or no money, and then with a promise of paying the original cost, perhaps with interest over a certain amount of time. The core of a credit definition is using somebody else's money. So this distinguishes a credit card from a debit card. It used to be your debit cards were your ATM cards. You used to go to the ATM machine, withdraw money, and that was pretty much how you could use your debit card. But then the Visa and MasterCard added their logo, and so now you have this hybrid credit use of debit. And while the debit card takes money directly out of your account, the credit card is incurring debt. And that is why you will be building credit or registering an event on your credit report while you're using your credit card, but not your debit card. So what are the pros and cons of using credit? Obviously, the pros are you can buy things that you need. You don't necessarily need to have the cash. It's convenient. You can establish credit for purposes of taking out larger loans. Sometimes for jobs, credit becomes an important issue. And you have a record of purchases. Obviously, there's cons with using credit. Interest is a big one. Fees, annual, late, over the limit. Credit cards may tempt you to buy things you don't necessarily need, the impulse buy. And it then requires you to really track your budget and your expenses to make sure that you can pay that bill off at the end of the month. So we've talked about the pros and the cons of credit cards. A couple of items that we didn't mention is that with a credit card, you have a dispute mechanism that caps your liability at $50, and that's federal law. However, when you're dealing with a debit card, those are not governed by the same federal law, and so the dispute mechanism is different, and you have a maximum liability of $500, and that all depends on how quickly you file the dispute. It is conceivable if you wait too long when you're using a debit card to file the dispute that you may not be able to dispute that charge. Online payments, you can use them. I don't advocate for it because if that number is hacked or breached, then they have direct access to your bank account. Whereas with a credit card, you're just racking up debt. You would then dispute and get charged off your account. So then we have these prepaid debit cards. I think gift cards are probably the best form of them that most folks know. There's no interest, but you may have an activation fee or a monthly fee, and there may be some fees related to pulling the money out via ATM. It's not connected to a bank account, so in that sense, it's safer than a debit card, and therefore it is also safer to be used for online purchases. And it also allows you to put a artificial limit on your spending if you're only putting so much money on those prepaid debit cards. The last type of card that is out there are these secured credit cards. And these cards, you essentially are putting your own money up, and say you're securing the credit card with $500, and this is really your last resort. You can't get credit any other way, but you want to start to rebuild if you've had bankruptcy or really poor credit. So you'll put the $500 down, for example, and get a credit limit by a secured card. It has all of the same functions as a regular credit card. You make the payments. It'll build your credit history if you make them on time. The negative is that it's tying up $500 in our example, and the fees can actually eat up a lot of that. So it is possible for you to end up having to pay $100 in just fees to set it up, maintain it, and therefore you only would have access to $400 of the $500 that you set up to secure the credit card. And the interest rates on secured credit cards, as you can imagine, are significantly higher than they would be on mainstream credit cards. So if you're just starting out and you want to know how can I establish my credit, opening up a bank account or a savings account is usually the first thing that you can do. If you want to have a credit card, store cards are usually easier to get. Gas cards historically have been easier to get. Get a smaller, lower limit, credit limit, and make sure that you're making timely payments so that you can build on that. If you are having trouble getting a credit card, perhaps even before you resort to a secured credit card, is you may want to ask a friend or a relative to co-sign your credit application. But know this, that if you do miss payments, that means they will be on the hook for making payments for you. So you have credit. What are the ways that you can protect it? Fraud alerts you can put on your account. It's up to a year. And what this does is that it forces any new request for credit, whether it's a credit card or a loan, to go through additional hurdles to verify that this is really you that's seeking the credit. It doesn't stop the credit from going through. It just adds a few more bumps in the road. To contrast that with a credit freeze, which completely freezes your credit. You cannot use it. No one else can use it. You get a PIN, and with the PIN, you can freeze and unfreeze, but give it a few days to make sure that the unfreeze process goes through. The fraud alerts and the credit freezes, they are federally mandated set of rules and procedures. You have federally mandated protections, and there's obligations placed on the credit reporting agencies with fraud alerts and credit freezes. Both are free, and in Maryland, you can put a credit freeze on your minor child's credit, as well as on the credit of any adult that you have guardianship over. Since these are now free, credit reporting agencies created this credit lock program, and there's fees that apply. I've heard $20 mentioned one time. But there are no legal protections. This is not a federally created mechanism. This is a contract situation. It's not really clear who is liable if a identity theft results in fake accounts being opened in your name. And while you can turn the lock on and off with a swipe of a finger on an app, there are some it lacks the protections that you might want to consider before adopting and paying into a credit lock situation. Brief conversation about early wage access, payday advances. This is different than payday lending, is when you go into a particular establishment that is going to loan you money based on your future earnings. These are either apps or employer-based. And the employer-based is, there may be some kind of a subscription or a monthly fee. They may put guardrails on how many times you can get a wage advance in a given year. And then the money comes directly out of your next check. Employers say this is a great way of retaining employees. Critics say, well, you're retaining them because they're captive. They can't leave because they now owe you money, and they're working to pay you money. So however it comes down, that's there is that mechanism. Third-party platforms, their apps like Earnin, Branch, or Daily Pay, that requires you to connect your bank account and provide some pay stub information. So now you're sharing that personally identifiable information with a third party. You don't need to, so there's a layer of cyber security issues to be aware of. But both versions claim not to be credit, because they claim they're not extending you their money, they're giving you your own money. It's a bit of a game, in my opinion, because they are giving you money that you don't have yet. And so if it's not credit, then you're not building credit. You don't have any of the federal protections that we're talking about. And so be very careful when engaging in any of these early wage access programs. So minimum payments. I think we all know, we see a minimum payment on our credit card. Maybe we're tempted to just pay that. The best thing to do is always to pay more than the minimum payment, even if it's $5 more, and here's why. CNBC looked at how these are calculated, and it's either a set dollar amount, in this example $35, or it's a percentage of your balance plus interest and late fees, and the percent could change depending on the bank and the lender. So the example was a $6,100 balance with a 16.61% interest rate. Assuming that no more purchases were made on that account, no late fees, that just paying the minimum on that credit card took 17 years and 3 months to pay off. And as you can see, that's over $7,200 in interest, which is more than the principal balance we're talking about, and results in a overall paid of over $13,000. So minimum payments are not there for you. They are there for the creditor to be able to make money. And that's really, the interest is where they make money, and minimum payments are not helpful to you in that sense. So credit scores. What it goes into a credit score? Obviously, your bill paying history, the types of accounts you have, your collection actions, outstanding debt. There's a lot of various pieces of information, and we'll go through them all. And points are awarded based on how they can predict you're likely to pay and repay the full amount due, so your credit worthiness. FICO, which is one brand of a credit score, has a new FICO 10T score, which is incorporating this trend data now that looks back 24 months to see how you're doing in the last 24 months. And that, in theory, will be helpful, because if you have some really bad history 7 years ago, but the last 24 months have been really good, this 10T score by FICO will be helpful to you. There's a lot of often questions about hard versus soft inquiries. Hard inquiries are when you reach out to make a credit application. That's a hard inquiry because you're asking for credit. Soft inquiry is when prospective creditors want to see if they want to offer you something, and so they'll make a soft inquiry. That does not count against you. So remember, I said the FICO is a brand of a credit score. If you subscribe to Credit Karma, for example, or you pull your credit report through TransUnion, you're not going to get a FICO score. You're going to get a credit score. So it's really important to know, if you're going out for a loan, if they're going to be pulling a credit score or a FICO score. And so if you are, for example, looking at Credit Karma and it tells you that your credit score is 749 and you think you're golden, and your lender uses FICO and under FICO you're at 700, that may alter the interest rate and the product and the ultimate loan package that you could get. If you want to get access to a free FICO score, Experian can provide it, as does the Discovery Scorecard. Otherwise, I think you can go through FICO and there's a fee in order to pull your FICO score. You can see there are 5 main items that go into creating your credit score. The largest is your payment history. How good are you at making payments, making them on time, making them in the right amount? The second largest factor is your outstanding debt. What is your debt to credit ratio? So if you have 10 credit cards and they're $1,000 credit limit apiece, and you have, therefore you have $10,000 in potential credit. You've maxed out 2 of those cards. So you have $2,000 in debt, $10,000 in total credit available. So your credit to debt ratio is at 20%. If you were to say close 5 of those cards, and so your outstanding potential credit is $5,000, now your 22,000 is not out of 10, it's out of 5,000, and so that increases your debt to credit ratio and makes your outstanding debt look more risky. Your credit history length. Have you been building credit for a year, or have you been building credit for 15 years? What is your longest running credit card or loan? How good are you on making those payments? What is the length of time that you have been building and dealing with your credit? So that's another important piece of the FICO pie. Pursuit of new credit. If you've only sought out a new card or a new loan once in the last 15 years, that's a positive. If you're all of a sudden going out there and filling out credit card applications everywhere, and come the holidays, you're going to be given those offers right and left, that can manipulate the credit score and make you look like perhaps you're picking up riskier behavior. And last is the credit mix. Do you only have credit cards, or do you have loans? Do you have school loans? Do you have secured or unsecured loans? What is the overall mix, and how well are you handling these various products? That provides credit reporting agencies another valuable piece of information. So FICO score, myth versus reality. I think there's definitely areas that are considered, and we're going to talk about the trade lines, credit inquiries, collections, etc. What's not considered is your age, where you live, where do you work, what's your income, what's your race, what's your gender. Those are typically what we would consider redlining, discriminatory factors, and FICO scores do not include that, and neither do credit scores. Other branded of credit scores. So what does go into your credit report? And here's a sample FICO credit report. And the first section, zone 1, is just your personal information, right? Who you are, where you live, what's your date of birth, your social, etc. That, while it's on your credit report, does not actually go into the score. Only zones 2 through 5 do. And so we're going to take those zones one at a time. So zone 2 is public records, bankruptcies, judgments, tax liens, pretty much anything in the public record that requires some kind of a monetary hit. There's no positive public record entry. So if there's nothing there, that's best. And if there is something there, you hope that it's in the distant past. Trade line, zone 3. This is a sample of what a current or okay trade line would look like if you pulled your credit report. As you can see, this one shows a 30-day late. Know that if the 30 doesn't mean that you were 30 days late on your credit card. It means that after 30 days, they would then report, and then if it's another 30 days. So in effect, this is a 60-day delay. So if you're 2 days late or 5 days late or even 15 days late on making a payment, it is not going to show up on your credit report. You have to be at least 30 days late before you get reported to a credit reporting agency. You may also find charge-offs here, settlements if your debt has been settled out. Delinquencies will show up as 30, 60, 90, sometimes even more. So you want to look at your credit report and see exactly what do your trade lines look like. In addition to trade lines, you may see trade narratives, and pretty much these are never going to be good, because this means your creditor has taken the time to actually type in more information, and they're never going to be, oh, Jane is such a great payer, highly recommend. They're always going to be, for the most part, negative narratives, foreclosures, repossessions, charge-offs, maybe a paid charge-off. That might be the best you could hope for. If it's an account is in bankruptcy, if there's been settlement, if it's gone to external collection. So trade narratives provide more information. And in this example, you can see it says account closed at credit grantor's request. That means that your creditor had reached out and not only closed the account, but reached out to the credit reporting agency to tell them that they have closed your account. One thing that you will not see in zones 2 to 5 through 5, but is included in the overall calculus, are these account status codes. And they may very well be somewhere in the background. You may not even see them on your credit report. And these are additional pieces of information the credit reporting agencies will use to give you a score. And that will show if your account is currently at 180 days late, and if it's in collection, or if it's an involuntary repo, or has the foreclosure process started, has an account been assigned, etc. So it provides a bit more information on the trade line or even the trade narratives. And again, these are rarely going to be good account status information. So how do you create, maintain, or improve your credit? If you want to create a good credit history and you don't have one, you get one card and you open it and you have undisputed account, which means you're on time, you make at least the minimum, hopefully more, and you could make that happen for 6 months. At least 6 months of good rating and good payments is needed before that becomes a positive exchange. You want to create a budget and follow it. A lot of folks will create a budget but not follow it. There's apps that can help you. An Excel spreadsheet can be your friend, and it's free. Don't exceed your available credit limit. If you go over your credit limit, that makes you look risky. So always stay under the limit, even if it's just under. Just keep an eye on where you are. Make your bill payments on time, avoid late fees, limit the number of cards. And remember, we talked about the debt to credit ratio. So if you're not using 5 of your cards, shred them. Let that credit stay open and available. But if you're not using it, then it's not going to negatively impact that debt to credit ratio. And then you want to review your credit report and fix errors. Anything that looks like it might be off, you definitely want to make sure that you fix it. And we'll talk more about what to look for. So again, resolve incorrect debts that are listed on your credit report. We just mentioned that. You want to keep all of your existing credit accounts in good standing. If you think you're getting into a situation that you're going to have some trouble, nothing stops you from contacting your lender, even a collection agent, to set up a payment plan. Something that takes ownership and control over the process and puts you in charge of what payments you make and when you can make them. talk to a credit counselor. But please be aware there's a lot of scammy credit repair companies out there that take too much money and provide too little service. And we'll talk more about that as well. So how long does something stay on your credit? As I mentioned, you want to make sure you're looking at your credit report, because studies show that up to 30% of the credit reports have at least one error in them. So if you can look at the chart, you can see that hard inquiries and soft inquiries can stay on your credit for 2 years. And remember, only hard inquiries count towards your credit score, but soft and hard will stay on there. Open accounts in good standing, they'll stay on indefinitely. That's great, you want that. And you can see that late payments can stay on there for 7 years. If you see a payment on this, say you've got a late payment entry from 10 years ago and it's still on your credit, clean it up. Write to your credit reporting agency and say, this has overstayed its welcome. It shouldn't be on there. It's been more than 7 years. Now, state law has some differences, so you want to make sure that when you talk to a credit counselor, you find out if these federal limits of 7, 10, or 2 years are different under your state law. Also know that a statute of limitations is different. So a debt may no longer be collectible because it's stale, but it could still remain on your credit report. And so you may want to look at your state statute of limitations and also compare it before maybe deciding, you know, if you've got 5 years left on a statute of limitations and you're going in for a loan and you know this is going to stay on there for 7 years, you may want to consider maybe coming up with a payment plan or a settlement to get that off now. So you can always take control of your credit and your credit report and your credit score in a lot of ways like that. So before collections begin, you want to get organized. You get your lender agreements, your terms of services, any of the documentation that was needed when you first created that account. You want to get your payment records, all your checks, get them from your bank, download them off your bank's website. Look at your statements, get those. If you've had debt discharged in bankruptcy, get those records. You want to have all of your payment records organized and in one place. Like I said, you can always contact your lender or your creditor for a payment plan. But if you want to start to work with a credit counselor or financial coach, the two we suggest you get in touch with is either CCCSMD, which is Consumer Credit Counselors of Maryland, or the Cash Campaign of Maryland, and they're local. If you're watching this and you're not in Maryland or not in an area that these two, I think CCCSMD also does Delaware, but if you're outside of this local area, you can contact the National Foundation for Credit Counseling and get a referral for someone reputable in your area. So debt settlement. This can be something that you can explore if you want to wipe out your existing debt. Now there's nonprofits and for-profit organizations that provide debt settlement services. And just because someone is nonprofit doesn't mean that they are good. So you want to research the consumer experience of the organization you're looking to hire and make sure that they have good reviews, good history, and that they do good work. Basically how a settlement works is that you're taking money that you could otherwise be paying towards a debt, and you're putting it into a separate account for the debt settlement company to then, when it reaches a critical amount, to then use that amount to try and negotiate. And basically they say, I've got $1,000 and I can use it to settle, you know, the following debts, or you can spend the next 2 years trying to chase it down through the court systems and garnishment. And if they're really aggressive, they can probably try to negotiate a good settlement for you. However, this process can take time. And in the time, you've got collection agencies on you. You may have your credit score is going to be impacted. Lawsuits could get filed. So you should know that while debt settlement is a viable option, it is a time time-taking option. And settlements stay on your credit report for 7 years. So be sure that that is your way out before going that way. And you should never pay upfront fees for these services for debt settlement. You wait until they have delivered, and then they get paid. Credit counselors and legal counselors, lawyers, can also help you with this process as well. Debt consolidation is a similar concept, but here you're borrowing more money to consolidate all of your debt and pay it all off at once. And sometimes if you work with a credit counselor, they may be able to use their skills and their negotiations to lower the overall amount of the debt that's being consolidated. HELOCs, second mortgages, those are common ways of getting a debt consolidation loan, but you can get other secured loans as well. However, before choosing to go to debt consolidation, it's important to make sure that you have considered your spending habits and that you're simply not going to run up the now emptied out credit cards. You want to, again, make the budget and stick with it. And make sure that you can't make adjustments in the budget to be able to pay these debts off without going the consolidation route. Make sure you've already explored lowering payments and coming up with payment plans. And look at credit card balance transfers, and they can sometimes be 0 interest for a year. You want to do this with an empty credit card, because if there's a balance on that card, the payments you make go towards the 0 interest first, while the existing balance continues to accrue interest at whatever your interest rate is. They don't make your payments work for you, they make those payments work for them. And so you don't want to use that card that you're balancing transfers on, because the items you're purchasing will continue to accrue interest during the lifetime of your payments until the 0 interest balance has been paid off in full. The Consumer Finance Protection Bureau has some good workshops and resources if you want to explore debt consolidation. Before we get into debt collectors, it's probably good to understand the 3 different kinds of actors that are in the marketplace. Creditors are those who own the debt. They're the ones you did your original contract with. They can collect on their own debt, and their collection activities are exempt from federal law, but maybe not from state debt collection laws. Debt collectors in Maryland are hired by either creditors or debt buyers, who are another form of creditor now, to collect on the outstanding debt. Under Maryland law, they have to be licensed. And so that's something you should ask. If anyone calls you, ask them if they're licensed and get their license number and then verify it. Debt buyers are third parties who are buying debt that a creditor has deemed uncollectible. And Encore, which is one of the bigger debt buyers out there, in 2016 spent $900 million buying almost $10 billion in debt. And so they bought the debt at 9 cents on the dollar and recovered it at 22.5 cents on a dollar. So debt buying is a lucrative business if you can collect on it. And as I mentioned before, a debt buyer now becomes the creditor. But if they don't have all of the documentation from the creditor, there may be chain of custody problems, and they may lack the files necessary to be able to properly and completely collect on the debt. And we'll talk about more later why this is so important. So the debt collection process has started. What should you do? What can they do? What can't they do? And what you can do? These are all very important in the federal and state protections out there. Debt collectors can't call you at inconvenient times. They can't contact you at work if you've told them you're not allowed to get personal calls there. They can't talk about your debt with anyone but you, your spouse, or your lawyer. They can't threaten you. They can't use profanity. They can't repeatedly use the phone to annoy you, but as we all know, robo-dialers can call 100 times or more a month. They can't lie to you about who they are, what the debt is, and what your rights are. And they can't collect on stale debts. Remember, we talked about statute of limitations. If the debt is beyond that period where it's no longer collectible, debt collectors can't collect. It doesn't stop them from trying, and they will use a lot of tricks to get you to revalidate the debt. So they may say something like, well, can't you afford even 1 cent a month? Come on, you can afford 1 cent a month, can't you? And of course, you can afford 1 cent a month. But if you say, well, yeah, I could, you have now inadvertently revalidated the debt, and now it is full-blown collectible again for a new statute of limitations running period. So if this debt is stale, the best thing to do is to end the call so you don't inadvertently say something that revalidates. Debt collectors can definitely call other people to find you without revealing why they're looking for you. And if you're sued in court and they win with a court order, they can garnish your wages or garnish your bank account. And if you've consented to robocalls, and believe me, you have in the fine print, they can use robocalls to call you as much as they want, unfortunately. So what are your rights when you get a debt collector on the phone? You have the right to know who they are, the name of the company, the address, the phone number. They may give you their first name or some kind of ID number. You have the right to ask for the debt to be validated, the validation notice. That would be the amount of the debt, the name of the original creditor, and be careful that they're not padding. It's called overbiffing for some reason, but be careful about over padding the debt with fees and legal costs that maybe they haven't earned or the contract doesn't entitle them to have. You have a right to know what the debt was for and when it was incurred. You have the right to know if it was your debt or maybe it was someone else's debt that you had co-signed, for example. And you can decline to continue to talk with them until you receive this information and have a chance to review. That is perfectly within your rights. If you don't want them to call you back, how do you do that? Well, you send a letter by mail asking the collector not to stop contacting you, and then keep a copy of the letter for yourself. After they receive it, they can only contact you to confirm that they're not going to contact you anymore. And you can get sample letters at the CFPB website to use. One note, in the fine print, the debt collector, the creditor may have spelled out the way that you can stop them from calling you. So it may be a special phone number or a special email. There's also some contracts that say that their ability to call you and call you through robo-dialers is a material term of their offer to extend credit, and that there's no way you can stop them from contacting you. And that's actually gaining some traction in courts. But until the CFPB says that a letter doesn't work, I suggest sending the letter and getting the harassing calls to stop. If you want more on debt collection after this video, the National Association of Consumer Advocates has a lot of micro webinars that talk about different aspects of debt collection, credit, debt buyers, etc. So you may want to take some time to go to that website and review what they have for you as well. One of the best books on debt collection process, creditors, debt buyers, is this book, Bad Paper by Jake Halpern. And he wrote this book based on the fact that his mom got a call from a debt collector on a debt she owed. She had completely forgotten. She paid it off, and a month later, she got another call from a different debt collector for the same debt. And so he wanted to know, how is that possible? How is it possible for the same debt to be collected by two different debt collectors? And that's when he found this, what he called this underworld of debt collection in upstate New York. The book is available at Montgomery County Public Libraries. You can check it out in hardback or ebook or even in NetRead. But it's an amazing story of how debt buyers work. And so when they buy debt, they will then cut it up and divide it out to their various staff members to start collecting on it. But sometimes those employees will download their book of work onto a thumb drive and literally sell it to another debt buyer on the side. And so there may be multiple people who are trying to work the same debt. And this is where the chain of custody is very, very crucial, because the creditor has all of your documentations, and if they sold it to the first line debt buyer, they may have your documentation. But people who have now bought it from the debt buyer or bought it secretly from the debt buyer's employee, they're not necessarily going to have the documentation to really be able to collect on your debt. This book is fascinating tale. I won't spoil it, but there's a scene that involves a barbershop, a machete, and debt collection. So check it out. So when you're dealing with a debt buyer, and obviously if you don't have any memory of working with Encore or Portfolio or some of the other major companies out there, you want to make sure that they can legitimize the debt and that you owe it. So, you know, you have to ask them, who's the original creditor? When did you buy the debt from the original creditor? Do you have all of the documents? And more importantly, is this really you they're after, or is this really a debt collector that's calling you, or is it a scam? And we'll talk about scams in a bit. Portfolio is a company that is a debt buyer that the CFPB hit up with $8 million in fines and also required $19 million to be returned to consumers, because Portfolio was buying debt that it knew it was inaccurate. It knew they lacked the documentation, and they knew it was otherwise unenforceable when they were trying to collect it. And so that knowing, aggressive attempt to collect on debt they knew they had no right to do earned them a hefty fine and refunds. So if you think that you are dealing with a debt buyer and the debt is not yours, challenge it in writing within 30 days of the first contact. Then until they can verify the debt, they can't contact you. So that'll give you some breathing room. You can negotiate a settlement and make it in writing. It's easy to negotiate verbally, but reduce the agreement to writing. If you can email back and forth so there's a record of what the negotiation is, that's best. So if you owe the debt, you owe the debt, and the amount is correct, and the debt is not stale and uncollectible, then settle it if you can. Then you may want to negotiate what the trade line says. Maybe you want to negotiate that they don't put any trade narratives and what the account status codes are now that you've learned about them. So you can include that in the overall negotiations. And as we'll talk in more detail, you want to respond to any lawsuits that get filed by debt buyers or by creditors, because you want to avoid default judgments. So there's now a collection lawsuit, and keep in mind, I've seen examples of lawsuits that get filed but not officially served. So you first have to get a summons in the court so that you know you are being summoned to court. And I have seen instances where debt collectors are contacting consumers and saying, sign this document and I won't file a lawsuit, but the lawsuit's already been filed. So that's one, a lie, and they can't lie to you. And two, these agreements may have a confess judgment clause in them. And that basically means you're confessing that there should be a judgment against you, that the amount is entirely correct, that you have no defenses to this collection. And the confess judgment clauses in consumer contracts is against Maryland law. And so when you're dealing with it in the debt collection context, it becomes a little more problematic. Also be aware that a consent judgment is very similar to a confess judgment, and so that might be something that you're offered in court. Before you sign anything like that, make sure you owe it all, every last penny, and you don't have any defenses. So pre-trial, you get a summons, don't ignore it. File a notice of intent to defend here in Maryland District Court. It's a form you can get online, and that lets the judge, the court, and the other side know you're in it, you're going to fight it. And what Jake Halpern learned in following legal aid in Georgia was that when someone showed up to defend a collection lawsuit, chances were they were dismissing it because they maybe did not have the records they needed. It was only when someone didn't show up to defend that they were then able to get a default judgment. So it's really important to not ignore that summons. Now, you can get legal advice for free from lawyers here in Maryland by contacting the district court self-help, and the website's there on the slide. And while they won't go to court for you, they won't represent you in court, they will give you all the advice you need to represent yourself. You can also contact legal aid or the Maryland Volunteer Lawyer Service if you meet their program requirements. So you can get legal advice for free potentially, or if you want to contact the National Association of Consumer Advocates, you can probably find a consumer lawyer who'd be willing to talk to you. Here in Montgomery County, you can also contact the Montgomery County Bar Association as well. So now you're at trial. The creditor, debt buyer, has to prove that you owe the debt in full. And you have defenses, and it's best to file your defenses in writing. And so you can mail them into court and ask the clerk to file them in the docket, or you can walk them into the courthouse and hand them in to the clerk's office. Your defenses could mean, I don't owe that debt, it's not me, or I don't owe that much, here's why I think the amount is wrong. Or maybe you already have a payment plan in place, so there's no point in having a lawsuit. Is the debt stale? In which case, is this an illegal lawsuit to begin with? Do the creditor have all the necessary documents in order to prove their case? If they don't, then you can ask the case be dismissed. Has the debt been discharged in bankruptcy? Is it filed in the wrong court? Are you in Anne Arundel County, in this case, filed in Montgomery County? Are you a victim of ID theft? Is this not your debt that you're being sued on? Whatever your defense is, make sure you put it in writing. And for anyone who knows folks in this situation where English is an issue, the courts have interpreters and translation services, so definitely you want to contact the self-help and ask about language assistance as well. Post-judgment. So you've been through the whole trial process, and now there's a judgment against you. You have 30 days to file an appeal if you think that the judge didn't listen to your defenses, or maybe you want to try to work out a settlement. Maybe the judgment is for $10,000 and you go up to the creditor's lawyer after trial and you say, look, I can come up with $5,000. Why don't we settle the debt for $5,000? Remember, settlements will stay on for 7 years, but at least you're not going to now be dealing with discovery and garnishment for the foreseeable future. So a judgment creditor, a creditor who wins judgment, has the right to take discovery in aid of enforcement, and that's basically trying to get information to help them collect. They can serve interrogatories, which are questions you have to answer in writing, depositions. Don't ignore these, because if you do, they can ask for the court to issue a body attachment. It's kind of like related to like a warrant for your arrest. You don't want to go down that road. But if you think the questions they're asking are just too extensive, again, reach out to the district court self-help or your lawyer to get some legal advice. Now, what can they garnish? They can garnish your bank accounts. They can garnish your wages. They can garnish your commissions. They can garnish up to 25% of your wages, but if you're on a pure commission kind of work, they can garnish up to 100% of your commissions, which is going to put you in a really dire circumstance if that's what they opt to do. Certain exclusions from garnishment apply. There's exclusions for retirement accounts, joint marital accounts, and other types of accounts. And there's certain protections that are available. You can ask for up to $5,000 to be protected if it's related to work. So if you want to protect your work truck and your tools because you're in the construction trade, for example. You can also ask for up to $6,000 in protections for cash or property. Your legal counsel can help you figure out what motion that you would need to file, and these motions are available again on the website. You can go through district court self-help. Note, there's no protections if what you owe is child support, student loans, or taxes. Those are the big three that you just can never dodge or evade. So keep that in mind. And once you're paid off, seek an order of satisfaction so that they can come back again and again. Not that they would do it on purpose, but record keeping can sometimes be lax, and maybe the judgment creditor fails to realize they haven't finished collecting. Debt collection scams. There are a lot of different forms of scams out there these days. We'll talk about student loan scams in a moment. We briefly touched on the possibility of consolidation or settlement scams when you're dealing with companies that are more interested in taking your money than helping you with your money problems. We've talked about the debt buyer, resales, and how that can result in a scam collection. In fact, the FTC announced in late September Operation Corrupt Collector, and that is going after phantom debt collection was one of many. So the FTC, the CFPB, and attorney generals in numerous states and a whole host of nonprofits have banded together to try and deal with these corrupt collectors. And so phantom debt collection is when debt collectors are trying to coerce consumers to pay debts they don't owe, or the company has no right to collect. There may be debt collectors out there that are just outright lying to you about debts. They're violating the law left and right. So the FTC and the CFPB have started to really hone in on these corrupt debt collectors. Debt collection also can come in phone scams. We have all heard about the IRS is about to come and arrest us because we owe back taxes. They could pretend they're from a law firm. If someone's calling and if they're saying they're from a law firm, they should give you the name of the firm, a phone number, and an address. A real legitimate law firm has no problems providing that information. You may come across certain law firms that will only give you a website, and you go to the website and there's just no way to contact them. If you can't get a name of a lawyer or a principal at the law firm or anything that you can then verify against the state bar rolls and roster, that's a big red flag that this company is trying to hide who it really is. If they ask for gift cards or wiring money, that's another red flag. If they're not giving you all the information you need, or they're not providing you that validation notice, if they're talking about debt you don't know anything about, that could be identity theft, or it could be a scam call. If they're asking you for personally identifiable information to verify and that they're speaking to you, be very careful. I've had an experience where CVS was calling me about prescription renewals, and they needed to make sure they were talking with me, and they wanted my social security number, which I was never going to provide, even though I knew it was really CVS calling me. So be really careful when dealing with phone scams or potential phone scams. So student loan scams gets its own slide because especially now with CARES Act out there, you're going to get a lot of phone scams claiming that they can provide you immediate loan forgiveness or debt cancellation. There is no such thing. In fact, even if you're part of a federal program that was supposed to provide you loan forgiveness, it took a lawsuit and several years to make that happen. If there's any pressure to pay upfront fees to make student loan help Remember, we've talked about not paying for things up front. If they're asking for any kind of third-party authorization, something like a power of attorney, or if they want your FAFSA PIN, run away. That's not a good situation. So be aware that with the CARES Act and COVID, you're going to get a lot of maybe phone scams, emails, offering you all sorts of debt relief when it comes to student loans. What has been the greatest impact on debt and credit by COVID? Obviously, if folks are in an unemployed situation, they're not making payments. They can't make payments. And so deferments and forbearance agreements have been offered under the CARES Act. And so creditors should not be penalizing you if you're getting a deferment or a forbearance, because FICO, for example, would not treat these programs negatively. But many creditors are probably, or anecdotally, I should say, are not processing documents correctly. And so it may end up triggering a negative event on your credit report. The difference between the deferment and forbearance, there's many different types out there, and depending on your lender, this can mean that there's just extending the loan term, or it means that when you come back to paying, you have a giant balloon to pay. So you want to make sure that you understand the terms of the deferment or the forbearance agreement that you're entering into. With the COVID, the golden rules of Finance 101 have been bent. At the top of the hour, I said, don't only make minimum payments. Obviously, if money is tight, you're lucky if you're going to make minimum payments. While you're trying to be fiscally responsible in normal times, people are using more credit now. They're taking loans against their 401k, maybe as debt consolidation or debt settlement, perhaps just to live. They may be minimizing their contributions to their retirement accounts. As I continue to say throughout this program, if you find yourself in a situation, negotiate with your creditor. If your creditor has cut off all negotiations and they just don't want to negotiate anymore and they've done all they're willing to do, that's when you get a credit counselor or a financial coach involved to help you with the next steps. On this slide, I'm providing some resources. Obviously, our website is a good place to go for some basic information on these topics. The Maryland Attorney General's as well has a lot of additional information on debt collection, credit, and debt generally. If you want to verify that a debt collector is licensed, you would go to the Collection Agency Licensing Board, and we have their web address there. You can get your credit report, annualcreditreport.com. Know that if you get one free report per agency. So if you want, you can every 2 months go to a different one. And note that there's, in addition to the big three of TransUnion, Experian, and Equifax, there's 2 more credit reporting agencies that are becoming more and more important. One is a Novus, which doesn't provide a credit score, but it does provide a credit report. It's primarily used by landlords, but it is becoming more and more important outside of that area. And then there's the National Consumer Telecommunications and Utilities Exchange, NCTUE. So they are obviously, as the name says, being used by telecom and utility companies. So if you freeze your credit with the big three, nothing stops someone from opening up a fake account in a T-Mobile, for example, because a frozen credit with Equifax doesn't stop your credit report from being used under NCTUE. We've talked about the FTC and the CFPB. The Federal Reserve Board is going to have some good information on deferments and forbearances, and some good information on dealing with banks. And again, if you want more information from FICO, there is the FICO address as well. So last is this would be the spot for any questions. And before we take any questions, I wanted to provide our contact information. And Our phone numbers during the pandemic are unfortunately off since we are on mandatory telework, but you can reach us by email right there, which is consumer@montgomerycountymd.gov. If you can, you should follow us on social media as we put daily alerts and consumer news on our pages. And Facebook is the only one that has a slightly different address. That's ocpe.consumerwise. But Twitter, Instagram, and YouTube, you can follow us or subscribe at consumerwise. And we look forward to sharing more information with you. Thank you.